Attorney Kip Malek. Today I'm going to be talking about a case involving, or this is an appeals case. So within the workers' comp system, when you go to hearings, and like if it's can be two courses of action you could take after that hearing. So if it's like you're trying to get the claim allowed, or you're trying to get an additional condition allowed in your claim, and that's denied, then you would file it to court, basically what you would think of court, the trial with the jury and all this stuff. And those are called right to participate issues. And then if you're trying to get anything relating to like compensation, that's called an extended disability issue. So extended disability issues don't go to court. You don't file those to a jury to determine whether or not you get compensation. Instead, you file those to the 10th District Court of Appeals, and that's here in Columbus, and that's called Mandamus Action. So what it involves is they're legal issues, and so there's not a jury involved. So you're gonna, and the way it works is you file to the 10th District. The parties, whoever's disputing the issue, draft their motions, and then they'll make a legal argument before a magistrate, and then the decision is made, and then you could escalate that. If you're unhappy with that, you could escalate it to be heard by judges, and then you could escalate that to the Supreme Court of Ohio. So this case involves an issue of maximum medical improvement, or the termination of TT. So when you reach, every workers' comp claim has a lifespan, and you're not going to get temporary total disability forever. It's called temporary. At a certain point, your temporarily and totally disabling condition will become permanent in nature, and then once it becomes permanent, then you're no longer entitled to temporary total disability. And the basis of that, whether to terminate or to continue paying the comp, is whether or not the allowed conditions in the claim have reached what's called maximum medical improvement. And maximum medical improvement is basically a treatment plateau. That's the way they describe it. So a treatment plateau, you're neither going to get better, you're neither going to get worse. You're just kind of stuck. So it doesn't mean you got healthier. But to prevent a finding of MMI, you either have to have like treatment that's authorized, or you have treatment notes that say, hey, this guy's getting better, or hey, it's getting worse and we need to do X, Y, and Z type of action. So in this case, this involves a woman, and what's the case called? It's a 10th District case, and the case is actually called Foster versus the Industrial Commission. So the Industrial Commission is the other party to the thing. So she and through her attorney, wasn't happy with the result of the Industrial Commission's decision, so they filed this Mandamus Action. So anyways, so a little bit of background. So this woman, I assume Foster, slipped on ice January 14th, 2019. She injured her right shoulder and neck. Presumably your claim was allowed. She was receiving treatment and compensation to her right shoulder. So a little bit, and so again, that's January 14th, 2019. So as long as she continued getting certification, she'd be entitled to comp. Comp can terminate, compensation can stop under various conditions. One of them is you go back to work. The other is your doctor releases your work on a full duty basis, or releases your work with restrictions. Your employer gives you a light duty offer commensurate with those restrictions, and you don't take that offer, you reject it, so then you're no longer entitled to comp because you didn't take that light duty job offer, so your comp terminates then. And then the other way is you're found to have again reached maximum medical improvement. So in this lady's situation, it just so happened that on August 16th, 2019, it was discovered that, oh, hey, I'm pregnant. So she was pregnant for 20 weeks. She was undergoing pain management and medication management, and her doctor was like, this isn't safe, or we gotta stop this. We gotta put this on hold until you have your baby. So the employer had an independent medical examination conducted by Dr. Sardo on September 25th, 2019. His opinion was, hey, this lady's MMI for the allowed conditions, since treatment for the allowed condition is on hold to pregnancy. Went to a hearing, the staff hearing. So there's two, DHO, SHO hearing officer relied upon Dr. Sardo's medical report from that independent medical examination and found that in fact she had reached MMI. So the date that you have reached MMI is the date that your comp stops. So I think in this case there was something wonky with the DHO, and it just so happens that the SHO is when the comp will stop. And so the attorney through or the claimant through attorney, etc., filed this Mandamus action, and it went through. These briefs were made for and against. And the other thing is in Mandamus actions. So if you're the claimant and the industrial commission fines for you, obviously you're not going to file the thing to the Court of Appeals, but the employer might. So in that case, the way it works is your attorneys write the mandamus. There's an attorney general representing the industrial commission writing their own mandamus supporting the position of the industrial commission, and then there's an employer filing like their counter arguments. So in this case, the claimant wasn't happy with the decision of the industrial commission, so it was that claimant versus the AG representing the industrial commission and the employer representing, or the attorney for the employer representing the employer. So the appeals court basically went down and they cited another 10th district case, and it was called Brown versus Plastic Products Division. And then that person had shoulder surgery authorized and it was pending, and then 3 weeks prior to that shoulder surgery, that person was found to have blood clots, so that postponed the surgery until it was found safe to have the surgical procedure. The employer obtained an order. They went to the industrial commission. They got an order terminating the TTD on a finding that the blood clot was the current cause of the inability to work, or the reason why the person was, that's the reason why they're not working rather than the work injury. It's similar to the situation here. Again, they're saying, hey, it's not the work injury, it's this lady's pregnancy. Pregnancy has no relationship to the work injury, therefore this person's MMI. So in that case, Brown versus Plastics, they referenced another case. So this is kind of how these things go. It's all about case law. That's why case law is important. It's called precedent. Whenever you're the Supreme Court, they're relying on precedent, or they should be, except when they reject precedent. That's not good, but they do occasionally. But they refer to the Supreme Court case called Waddle, which said a non-allowed condition cannot be used to advance or defeat a claim for compensation. So, which is similar to this situation. And then the other thing, so going back to this case, rolling back, the court basically said, the appeals court said, similar to these, this Brown and this Waddle situation, a non-allowed condition, in this case pregnancy, interrupted treatment that medical providers clearly contemplated as promising some improvement. So the medical providers in this situation, I think they were wanting to do, for this pregnant lady, I think they were wanting to do either injections or surgery, and those injections or surgery were anticipated to make her shoulder situation, the allowed conditions in her claim related to right shoulder, it was going to make her better. So remember, MMI, if you're at a treatment plateau, then you're MMI. But if you can get better, or your condition's getting worse, then you're not MMI. You haven't reached a treatment plateau. But if you're flat means no more comp. So it doesn't mean you're healthy, doesn't mean you're not healthy, but a lot of people will say, oh, I'm not better, I'm not the way I was. Well, that's not, it just, right now, have they thrown all the spaghetti on the wall, and are you getting better or are you getting worse? Otherwise, if you're flat, you're not allowed comp. You're MMI, you've reached maximum medical improvement. So, again, in this case, the issue was, no, it looked like the notwithstanding the pregnancy, if she would have gone through this stuff, it was contemplated that she was going to get better. So, and then the other issue was the interruption of treatment, because this is the issue was, well, what if you have a condition, like, I don't know, for instance, let's say, something horrible, like, I don't know, brain cancer or something, and I don't know, it's going to last for years and years and years. So in that case, we don't know when that interruption is going to cessate, when it's going to stop. So in that case, in that situation, that might be sufficient to, block your treatment, and then you're going to be found MMI. But in this case, they found the interruption of treatment was not of indefinite duration, i.e., she's going to have her baby at some point, presumably because she's human. And then once she has her baby, she could go back to the workers' comp plan, get her treatment, get her injections, whatever needs to happen. And then after that point, then we'll revisit and we'll see, okay, well, you've had your injections, you've had your treatment. Is it getting better? Is it getting worse? Or is it flat? At that point, months or however long after those injections, if it's flat, she's MMI, comp's terminated. So that's kind of the way it works. So I guess in a micro level, you could take this as, well, pregnancy is not going to totally 86 your claim. So, but but that's kind of more specific. But on a more general level, if you have some kind of medical condition and it does interrupt your workers' comp claim, the treatment plan and your workers' comp claim, that's not necessarily a fatal thing to terminate. That's going to cause you to lose your compensation. One of the things they're going to look at is this interruption in your treatment. Is it the finite thing? Is it going to stop, in a period of time that's not crazy years away? Is it weeks or months, and it's going to stop, and then you're going to be able to get back on the workers' comp treatment train? Or is it something that is going to basically interrupt the treatment for, years or months or years? And if you're getting your treatment plan stopped for months or years, then, you probably will be found MMI in the instance. So that's kind of a little bit more nuance in the maximum medical improvement and how it worked out in this specific situation. What happened is the court said, okay, this lady, we're rejecting the commission's order, and I think they said she's got to, I think it's sent it back. Let me see what they said. Boom, 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 boom. Yeah, so in this one, they basically said, SHO, you're wrong, which is nice. So they said, staff hearing officer, your decision was wrong. This lady's not MMI, and essentially, she's entitled to comp. So if she's not MMI, as long as everything else is kosher, she's entitled to comp. And so they rejected that Dr. Sardo's independent medical examination. So, a victory for the injured worker in that case. Next month, so this is the end of December, in the middle, I think in the end of January, there's going to be a case that's coming up that implicates the 412356F fund. So I'm going to, once that decision comes out of the 10th, I don't know if it's going to come out, I think they're having arguments at the end of January, but at some point when that decision comes out, I'm going to talk about it. It's kind of relevant in all you folks who are working or not working, who are receiving comp, or so I'll talk about that. I think it's going to be an important decision. This 412356F stuff has kind of spun everything on its heels, so it's not been a great. I don't know. It's been confusing. So let's just say that for the Industrial Commission, for the courts. And there's going to be a lot of legal shenanigans going back and forth before everything's clear on that issue. So that being said, if you have any questions, concerns, please email me, give me a call, give our office a call. If you have a work injury, I'm just going to emphasize this. I do this every flipping video. If you have a work injury, do not wait. Even if you think everything's awesome, call a workers' comp attorney, call us, Malek and Malek. Call somebody, look up workers' comp attorneys wherever you live, get a workers' comp attorney involved, have them look at your stuff. If you're not happy with what they say, talk to somebody else. Don't mess around with this stuff. I see things get messed up so easily because people wait and then they come to us and we can fix things to a certain extent, but there's some things our hands are tied. So with that being said, stay safe, stay healthy, no work injuries, and thanks for watching.